After pushback from the left after recent strikes on alleged Venezuelan narco-trafficking boats, we have attorney and former U.S. Navy Judge Advocate General Officer Don Brown here to help us set the record straight. Don, thanks for being here today. So the left loves to say that terrorism does not extend to drug cartels. Tell us why they're wrong.
Well, the left never pays attention to history. The notion of a U.S. president ordering military strikes on the high seas to protect American interests goes back to 1801, when Thomas Jefferson sent the Navy and the Marine Corps into the Barbary pirates' war in the Mediterranean when our ships were being seized. We saw it in 2009 for your viewers who have seen the movie Captain Phillips, which was a great story and a true story in which Tom Hanks acted out the role of the Navy captain who was saved off the Somali coast by the U.S. Navy SEALs whose ships had been captured by pirates. Self-defense on the high seas is something that is not unprecedented. It's very common. I could cite other examples. We don't have enough time. In this case, it appears that these two boats have been taken out already, have been full of drugs. We lost more Americans in 1 year to fentanyl coming across the southern border and from South America than in 10 years combined in the Vietnam War. The president has every right under the Constitution and under international law to act as he has done, and I applaud him for it.
So the AUMF, or Authorization for Use of Military Force, that was enacted post 9/11/2001 to give the president more power to bypass notifying Congress in acting against terrorism. So the term narco-terrorism, it's existed since at least the 1980s. Will you walk us through a little bit more of the legal justifications that the Pentagon is using in carrying out these strikes on narco-terrorists?
Well, first off, above and beyond the NUMF that you cited, which some say is unconstitutional because it encroaches upon the president's role as commander-in-chief, the president has authority as commander-in-chief to take action. Now, when you look at, and there have been numerous acts taken by presidents all throughout history, single and isolated acts falling far short of declaration of war. There have only been 5 wars that have been declared by the Congress, which are constitutionally authorized. But when you look at the United States Nations Charter, Article 51, nations have a right to defend themselves. We're not a member of the United Nations Convention on the Law of the Seas, but we do recognize certain principles of it. Under international law, there are 2 bases. There's what we call treaty and there's custom. And it has been a long-stated custom that nations can protect themselves on the high seas. And these are the principles under which the Pentagon is operating here and which the president is operating. He has every right to take limited military strikes to protect Americans. We saw when President Reagan did that, even before the NUMF was passed in Grenada. We've seen it all throughout history. Of course, Jefferson, we went into the Mediterranean for a full year. Jefferson was there before Congress got involved. So there is absolute historical precedent under the Constitution for the president to act under his authorities as commander-in-chief and under international law, which allows for self-defense in each and every instance.
Well, Don Brown, thank you so much for being here today. Former U.S. Navy Judge Advocate General Officer, we appreciate your time.
Thank you, Alexandra. Good to be with you today.